My name is Sonny Ferguson, and as mentioned, Judge Julie Palmer is joining me with this presentation. Just a little bit of information about myself, and Judge Palmer is going to do the same. I was a circuit judge in the Jefferson County division, and primarily did domestic relations. Well, not primarily, that's all I did, was domestic relations matters. I did it for a little more than 15 years and retired from the bench in 2011. And for some reason, a law firm in Birmingham wanted me to come and work on some mediation stuff. And I joined that. And that actually was a springboard. That was in 2011. That was a springboard for looking into what might turn into, and did turn into, the Private Judging Act. Julie, you want to tell some folks about yourself?
Sure. Again, Julie Palmer. Matter of fact, when Judge Ferguson retired, I ran for his spot that he had left open and won in 2010. I was on the bench for 6 years at the Birmingham Division of Jefferson County Domestic Relations Court. I was presiding judge over that court for 3 years. Left the bench in January of 17. I now do mediation and private judging. And I'm also the child support referee for Shelby County, Alabama. The private judging, I was lucky that Judge Ferguson helped get this bill passed in 2012. And I do probably anywhere from 5 to 10 to this year with the COVID I've got right at 19 cases that I've done so far this year. And that's mainly just because of the COVID. So that's something that we'll discuss in a little bit as well. So Judge Ferguson.
Okay. All right. Well, just to kind of give you a little bit of history with the private judging scenario, as I mentioned earlier, this law firm of Christian and Small in Birmingham asked me to join them and do some mediation work. But I also was asked about doing some arbitration work. In looking at arbitration in connection with domestic relations matters, there's no real provision to do so in the rules and regulations associated with arbitration. Just don't lend themselves very well to domestic relations matters. So I started doing a little bit of research and had some help with another fellow lawyer, and it started with that research coming out of California, and got to talking with some lawyers out there, and they had a successful program working as a private judge scenario. As a matter of fact, it worked so well out in California that there were several lawyers that set up their own courtrooms in their private practice, and were very successful. And those were the types of cases, maybe with celebrities, in big dollar cases that people were more prone to opt in the private judging arena. Long story short, we put together a committee and sat down and talked with a couple other judges and some lawyers. And we came up with an act and submitted it, had some conversation with some state senators and submitted the act. And right out of the chute, it got passed. It was signed into law on February the 7th of 2012. And after that occurred, one would think, okay, we're going to start getting all of this business. Well, fortunate or unfortunate is the case, the judges throughout the state of Alabama, some of which were not very receptive to it, and the lawyers didn't know anything about it. So we began to try and advertise the the thought of private judging. And one of the things that came back to us about it was that private judging was nothing more than judge shopping. And in my conversations with the judges throughout the state, they're saying, well, you're just shopping judges. And one side of that coin, you might be able to argue that point. The other side of the coin is that point's not really valid, because it's not one party's prerogative to go with a private judge. Both sides must consent. And in doing so, obviously, their lawyers have to consent to it also. So, in a sense, in my way of looking at it, and I know I'm prejudiced, it's not judge shopping. I'm going to use another word. It's kind of convenience shopping. So one of the things that we talked about is what can a private judge do? What issues can be heard by a private judge? And in doing so, in our act was modeled after part of California's, not all of it, but part of it, that it could not address jury trials. So the criminal cases were out, and the jury trial cases that were out because it just didn't lend itself for jury matters. So non-jury cases can be heard in the state of Alabama under domestic relations, contracts, torts, a combination of contracts and tort issues. In 2018, there were some inquiries as to, well, what if we get a case removed from probate court to the circuit court on an appeal, or not an appeal, excuse me, just have it removed. And so there was a push to include probate judges under this act. So we amended the act, and now it includes all former judges or retired judges that meet a minimum of 6 years active duty. That could be a district judge, a circuit judge, and now a private judge they can act as probate judge can act as a private judge. The thought is that because of, and I'll just put my personal experience into this equation. When I was on the bench for 15 years, it didn't take but 2 or 3 cases a month that could just really disrupt your docket. By that, I mean, let's say, for instance, I have a docket and I have 20 cases set on that docket for that day, some of which are initial divorces, some are modifications, some are real nice eyes, and then just a bunch of motions. Party AB comes in and says, we need to be heard, Judge, and it's going to take 2.5 weeks to try that case. Well, I can't speak for my fellow judges, but as was my rule, if I started a case, I would finish that case. There were a number of reasons for that, one of which would be the continuity of the case and the way it flows with the lawyers and the parties and with the judge, and that instead of starting it and stopping it and starting it and stopping it again over 2 or 3 months period of time, you as a judge, you have to re-educate yourself. The lawyers have to re-educate themselves. I think it costs more to the parties to do that. So from my personal perspective, if I started a case, I would finish it. So if it took 2 weeks or 2.5 weeks to try, everything I had the rest of that week in the next 2 or 2.5 weeks ended up getting bumped. Well, you just start kicking them down the road. And before you know it, instead of you getting to the case within 6 months or 8 months, you don't get to the case for a year or longer. Well, people want to have their cases heard. They're not wanting, they don't file their cases to be heard a year or 18 months down the road. They want to go ahead and get a judge. So this situation with a private judge would allow them to opt out of the state elected judge to a private judge and get their case heard in a timely manner. Now, I've already mentioned what types of cases would follow in the private judging arena. It's not a hard process to do. Once you sit down and you decide that you want to go on with a private judge, the next thing you have to decide is who's the judge you want to use. The State Bar Association maintains a list of qualified judges who meet the criteria set out by the state. And it's an easy matter to look at that list to find out who's on it. That list changes annually. Some folks want to join it because it's new to them, and other folks come off of it because maybe they're not doing or not having the opportunity to do the private judging on a regular basis. Be that as it may, there's a list, and if you want to go privately, you find who's on that list that you think would be suitable for your case. As I mentioned earlier, this is a joint case, joint petition or joint motion, so both sides have to agree on who that judge would be. Once you make that decision, you obviously need to talk with that private judge and see if he or she is willing to accept that case. And I'm sure in those conversations, there is some information shared concerning fees. A private judge can charge a fee for his or her services just like you would as a lawyer in a case. You can do it on an hourly basis. You can do it on a half-day basis. You can do it on a day basis, or you can do it as a flat fee. It just depends upon what you want to agree to with the parties. Personally, I feel like it's better served to do an hourly fee than to do a half-day fee or a full-day fee, etc. That way, you're being paid for your time, and they're paying for your time, not any extra or any less. So I've just mentioned how you would pick a private judge, and once that's done, it's a matter of submitting a petition or a motion to appoint that private judge along with the private judge's consent and consent of the parties, and submitted to the presiding judge of the circuit in which the case is pending or will be pending. I will say this about the judges who are already operating on a docket with a case. Let's say, for instance, there's a case that has been filed and it's been on the docket for, I don't know, let's say 6 months. And they, at that point in time, decide that they want to go privately. You do not have to go to that judge and have a conversation with that judge. You do, however, have to file your motion or your petition with the presiding judge of that circuit. So it could possibly be that the judge assigned to the case originally never knows what's going on until that case is removed from his or her docket. Now, you as a lawyer, you need to use your best judgment in having those conversations with that judge assigned to the case. Judges in my interviews throughout the state with this act and when we were promoting it, they told me they weren't so concerned about a case coming off of their docket. They weren't going to get their feelings hurt that you chose to go privately. As a matter of fact, several of them clapped their hands and said, "Great, that's just one less case that I've got to work with." But the caveat that was mentioned to me that all of them seem to agree with, and I would agree to it too, would be don't wait till the last minute and have your case go to a private judge. In other words, if that judge who has had your case blocks off 2 or 3 days to try your case, and the day before the case is supposed to try, you come in and let that judge know that you're going privately, that judge is not going to be happy because they could have used those 2 or 3 days for other cases instead of having basically dead time because they reserved those 3 days for you. So,
Judge Ferguson, I want to interject here just real quick.
Go ahead.
You were talking about the forms being filed. This is the private judge is a petition, joint petition to appoint a private judge, and it has to be paper filed. You cannot file it online. So it has to be paper filed with the clerk's office, and then it gets sent to the presiding judge's office for assignment. And the statute said the presiding judge shall assign the private judge that both parties want to use. It's not, well, I don't want to do it, or I don't like the private judge you've picked, or anything like that. It's the presiding judge shall sign the order appointing the case to a private judge. And the private judges, we have access to Zoom for motions and for hearings, just like any of the elected judges are. Well, in Alicourt, we handle everything through Alicourt once we finally get appointed. So I just wanted to put that in there when you were talking about the filing.
Right. Yeah, and that the way the act was designed, it was not discretionary so much with the presiding judge, as Judge Palmer says. Once that petition is presented to the judge, the presiding judge, if the private judge meets the state criteria, and of course, hopefully that's done before you ever file the paperwork, then that presiding judge must or shall appoint that private judge of the case. Once that appointment is made, you as a private judge become the judge of the case. Forget the label private judge at that point, because you are the judge henceforth in all respects to that case. So you'll enter your orders just like you would enter your orders if you were sitting in the county courthouse where you were elected to that seat. So like I say, you are the judge of the case. Now, where do you try that case? Well, you have a lot of flexibility there. You can try the case anywhere you want to try that case that you're comfortable with that trial. The very first private judging case tried in the state of Alabama was tried at the law firm of Christian & Small, which is where I work. And we set up a courtroom in a training room that we had. And we tried that case for 4 days. We had a court reporter, we had witness chairs, we had counsel tables, and it just as if you were in a regular courtroom. Now, my personal preference is if you can have a scenario where you can use a extra courtroom at a courthouse, that's an ideal scenario. And I think Judge Palmer and I both have found out that in Jefferson County, our judges are receptive to that. In the domestic relations building, which several of us judges helped design way back when, has a small courtroom on the first floor that is ideal for trying private judging cases. Up until recently, there was an extra big courtroom in Birmingham, but they have since received a fourth circuit judge to handle domestic relation cases in the domestic relations building. So that courtroom has been taken. But if push came to shove, you could rent a room at a motel or a hotel and do that. The downside of that scenario is there is probably extra expense associated with another location. And if you can prevent that extra expense, I'm sure everybody would appreciate cost savings because you're already paying lawyers on both sides and the private judge and maybe a court reporter. Again, where do you try your case? You can try it anywhere you want to with the parameters that I've just mentioned. Some people will say, is the law the same for a private judge as any other state or county judge? And the answer to that is absolutely. Like I said earlier, once that private judge is assigned that case, everything else is in play. You can drop the word private and just say he or she is the judge of that case because they are sworn in and have met all the criteria to handle that case until it is concluded. One of the questions that was asked of me some years ago is this a real court? Since it's private, is it a real court? Yes, it's a real court. Everything is the same. Just drop the word private. He or she becomes the judge of that case and handles it as any other case that they may have handled when they were sitting on the bench in the county courthouse and duly elected to that position. Ms. Julie, do you have anything else you want to add to any of that?
Well, it's just that the order is appealable, just as if the elected judge were on the bench. When we sign the orders, we don't sign it as a private judge. We sign it as circuit judge. There's the screen right now says how private are the proceedings. If it's not a file marked confidential, people can walk in and out of the proceedings just like they can any other hearing or trial that's going on. So it's not, the word private judge doesn't make it a sealed file or confidential file. It just makes it where the judge that both parties agree to hear the case. And then there's as far as the cost goes, we've all experienced as private practitioners the cost of your client flies in because your trial has been set, but the case in front of you is carried over to the next day. Or let's say the judges had an emergency in their family or just some reason that you're not there. So the cost can actually, this is not for the rich and famous. This is for anybody who wants to get their case done and over with. And rather than have your attorney or sit around all day because your case is going to be heard at 1 o'clock and then it's still not heard, and then you have to come back the next day, when your case will be heard. You know the times and the hours. There's no case before you. There's no case after you so that anybody has to be rushed. There is cost of security if you have it at someplace other than a courthouse. There is cost of the court reporter if you have it someplace other than the courthouse or in Jefferson County Civil Division, because we have no court reporters. But if you factor in the cost of waiting around all day for what you're going to be paying your attorney, I would dare say you would break even on this. It would, or save the parties money, and they get to know their destiny a lot quicker. Because the judge usually in private cases, you can get an order out much quicker because you don't have 10 orders in front of you that you have to get out for cases that you've heard in the last 10 days. Your order is usually a priority. I think the most I've had going on at any one time is 3 cases. But as far as orders go, you can usually get them out fairly quickly.
Okay, that's true. There as a private judge, there's really no excuse for not timely reviewing your documents, your notes, and getting out an order within a week to 10 days at the very most. The cases that I've tried, within 3 days, we were getting orders out because there was no real reason for any delay unless somebody was sick, such as a judge being sick. Excuse me. Let's see here.
Let's look at the forms now, Ms. Harris. There we go. To make this official, you need a contract signed, just as if you were an attorney and you have a new client, you have a contract which explains the services. And that's what this contract is. This has got my name on it, and I'm sure this is probably something Judge Ferguson actually developed, because most of my forms I got from either he or Judge Brian Huff. So this is just a contract. It explains out. I do a flat fee. I try to, most of the attorneys that have hired me practiced in my courtroom before, so I know if they say it's going to be a half a day, that it's really going to be a day, and that sort of thing. And everybody needs to sign it. The contract can be signed by one party, and then another contract a copy of the same contract be signed by someone else, by the other side. And then that is controlling on all parties. So do a contract, which is expected in any sort of business that you're in. And then I believe the next one is the joint petition for appointment. And again, it just says that it's a joint petition so that both parties have agreed to it. I had someone call me the other day that wanted to do a default on a private judge. But again, the statute says that both parties associated with the case have to agree to this being a private judge being appointed. So you can't do a default for a private judge. On mine, you've got where the parties agree, the approval by counsel, and then the private judge has to consent. And so I've included my consent as part of the joint petition. You can do a separate document if that's how your circuit wants it done, but that way everybody's on this, literally on the same page, having it done that way. Now, most of the parties, usually one side or the other, through an email contacts me to begin with about being a private judge in a case, so that the private judge can do a conflict. Because, we've been out in private practice. Maybe we've represented somebody in a case, or we represented them before we were on the bench, took the bench, and then afterwards, maybe they were a former client. So first, we always do a conflict check to make sure that either the attorneys or the parties aren't in conflict according to the rules. And then you have the affidavit of the private judge, which just says I'm qualified under the statute, and that is notarized. And then you have the order for the judge. So the order for appointing does not have to be filed in the clerk's office, just the first two documents, the joint petition and the affidavit of the judge have to be filed with the clerk's office. And then you have to, and then you get the order appointing the private judge to your presiding judge for them to sign and enter into aliquot. Now, I have had people file the complaint for divorce, then file the joint petition for private judge, because you can't file the petition for private judge and then file the divorce because you don't have a case. So the order is you file the complaint or your rule nisi or your petition to modify, and then you file the joint petition and all the other documents with that. And then the judge may sign, the presiding judge might sign that order appointing the private judge, but until the clerk's office changes the JID, the judge identification designation, it's not your case yet. You might have the order, but until the clerk's office changes it from the former judge to the current judge, it's not your case yet. So be sure to watch for that before you start signing anything. Anything to go with that, Judge Ferguson?
No, I think that covers those forms. There are a couple things that I probably need to address quickly if I can. You know, one of the steps in the article that is being presented, how private are your proceedings? And Judge Palmer touched on this a little bit. There is no separate docket at the courthouse to publish private judge proceedings. There may be 10 cases going on, but the general public would not know about it. So in some respects, it is private. Of course, if it's conducted at the courthouse, anybody can walk in unless for very specific reasons it becomes a closed proceeding. Anybody can walk in and see who the parties are, who the lawyers are, and who the judge might be trying that case. And sometimes they just do that to see what's it like to be in a real courtroom. It's only specifically private if the case is closed for very specific reasons, and those are fairly rare. They are not the normal scenario. As far as court proceedings, both Judge Palmer and myself have talked about possibility of court reporters. There is not a standing record of a private judging case unless you provide a court reporter. Somebody's got to pay for that court reporter. Generally, the parties will either agree to split that fee or the lawyers agree to split that fee for their parties, or they sometimes don't have a court reporter. You know, years ago when I got on the bench, each circuit judge in our county had a court reporter, including the domestic relations judges. Due to cutbacks in the state, court reporters were the first things we lost. But since we didn't try jury cases and we were not, quote, on the civil side of cases, they never reinstated court reporters for us in Jefferson County. Now, the judges throughout the state of Alabama, the great majority of them try other things besides domestic relations cases. Most of those judges have their own court reporters. So it just depends on what county and what judge you have as to whether or not there's a court reporter. But keep in mind, private judges don't have their own court reporter. So if you want a record that potentially could be appealed, you need to provide your own court reporter. Now, let's talk a minute about appellate process. For the first couple of years, there were several judges throughout the state that thought the private judge lost jurisdiction of the case once he or she entered their final judgment of, and we'll say in domestic relations, entered their final judgment of divorce. Meaning that private judge no longer had any authority over the case. Well, if that were true, how could you handle a motion for reconsideration? How could you handle a motion for new trial? When we looked at the statute and when it was amended in 2018, that gap, or I say gap, that thought that that private judge lost jurisdiction upon the entry of an order was closed, and so he or she still would have the authority to enter any post-judgment motions and orders. As a matter of fact, there is some school of thought, and it has not been addressed to my knowledge, that once a private judge has been assigned to a case, whether it is a original divorce or a post-divorce matter, that he or she would remain the judge of that case for all subsequent proceedings. There's nothing in the act that addresses that specifically, one way or the other. The best rule of thumb, from my perspective, and Julie, if you've come across this, please speak up, is if there's a reason to doubt whether or not he or she, as a private judge, maintain jurisdiction of that case down the road, just get them appointed again and close that gap and be done with it. Now, there were some, when we first talked about this act, somebody mentioned, well, Judge, what if the parties or one of the lawyers don't like the orders that you enter? Can they opt out of the private judging scenario? The answer to that question is a simple answer, and the answer is no. Once you become the judge of that case, you're just like any other judge, and if they don't like the rulings, you can appeal those rulings, but you can't get them removed except for significant cause, and those are fairly rare in the state of Alabama. So if one party says, well, I didn't like what the judge did, he set visitation schedules that were ridiculous. Well, if you don't like it, you can appeal it, just like any other case that is tried in the state of Alabama. So appellate rights are alive and well with private judging cases. When we first talked about this act and how it might help lawyers, judges, and parties in the state of Alabama, we were looking at cost, we were looking at stress to the parties, we were looking at courts' dockets and the backlog of those cases, and the timeliness of getting orders out. Years ago, and I certainly won't mention any names, I was involved in a case that was a custody case. We tried the case, say in June, and the judge took it under advisement. And July, no order. August, no order. September, November, December, no order. And, from my perspective as a lawyer and as a former judge, to me, that's doing people a disservice, not getting an order out. So one of the one of the things that we were trying to address is with a private judge, there's no backlog of cases for that private judge not to be able to sit down and address that order and get out an order in a timely basis. That, oddly enough, that particular case, that judge got voted out of office, and we never got an order. We got a new judge in January, and that new judge says, well, what can I do? I didn't try the case. I can't enter an order. And that judge was correct. We tried the case again that next summer, and the next judge did the same thing. So they sat on the case for 5 months before they entered order. And these poor couples sat on their case for 14 months before they got an order after it had been tried the first time. That's absurd. So again, that was one of the things we were trying to address. So then we start looking at, what are the real advantages to having a private judge in his private judging good for me as a lawyer or as a party. And there's several things that we talked about, and I'll just kind of go down this list pretty quick, and Judge Palmer, if there's other things that you can think of that you want to talk about, please feel free to join in. Is that with a private judge, you get the specialized expertise of that judge. In our case, Judge Palmer, in my case, all we tried were domestic relations cases. So we're supposed to know what we're doing. So that the specialized expertise. Expediency of matters being heard promptly. Let's get to it. Let's hear it. Let's get it done. The cost effectiveness. Well, if you're a lawyer handling a case, and that case gets set 3 times before you ever get to trial, each time you're billing for your time, the client is receiving that bill and having to pay each time to get ready before they ever get to trial. That costs a lot of money. Private judging, you don't have that. You set your case, you try your case. Timeliness, because there are fewer delays. That's what I'm just talking about. And this may be the only private judging case that this judge is handling at a time. And if he or she is handling 2 or 3 cases, it's still not like a normal circuit judge. It was not uncommon for me to have a docket with 700 or 800 cases on that docket. Even if it were 300 cases on that docket, that's still a handful that you've got to work through. Now, granted, not all of them end up being tried, but you as a judge have no control over that. Can the sitting judge, that state judge that's assigned your case, send this case to a private judge? There's nothing in the statute that says that they can, so the answer is no. Can they suggest the parties consider it? Absolutely, they can. There may be very specific reasons for that. And it could be a conflict of interest. It could be that that judge thinks that these issues are so complicated that it's going to take a long time to try, and it would be better suited for a private judge. There are several reasons for doing that. I, as a circuit sitting judge, did not take any pride in the fact that I had 400 cases pending and that these were my cases. Again, getting back to whether that judge, sitting judge, would get offended by having that case removed from their docket, it really should not come into play. And as I mentioned earlier, my interviewing judges throughout the state, the only problem they have with it is the timeliness of the request such that it does not mess up their docket.
Well, Judge Ferguson, I have a case now that I'm mediating. We broke for lunch while I'm doing the CLE, but it was filed in December of 2017. The judge in the case is fighting stage 4 cancer. So he is down at MD Anderson fighting for his life. These parties would like to have their case heard. If we can't reach by agreement today during the mediation, I've already told them that this is a perfect case to go hire a private judge, because their judge is not going to be hearing this case anytime soon if he comes back to the bench at all. So that's another thing. This has been pending for 3 years. There's no children. It's just strictly a property division. And so hopefully we can get that done here, but oftentimes people just want their story heard by the judge. Once the judge hears what I have to say, they'll award me everything, and the other side will get nothing. So sometimes you just can't settle cases, and this would be a perfect one right here. One of the biggest cases out there right now is Angelina Jolie and Brad Pitt hired a private judge. And Angelina Jolie wanted the private judge removed because the Brad Pitt's attorney apparently has used this private judge many times in the past. The courts ruled there that they couldn't be removed because you can hire, as an attorney, you can hire me 5 times in a row. And the other side, and I'm sure would be aware of that, but just because you frequent a certain private judge, it's not a conflict of interest, is what this California case ruled on. So that's been really interesting to see.
Well, keep in mind also that at the very beginning of the appointment of a private judge, the parties consented to having that judge appointed. So the lawyer and the party should be doing their homework and should know that up front before they request that certain judge, you know?
Yes.
Now, you know, there's really no difference with that scenario. Let's say, for instance, we're not dealing with a private judge. We're dealing with a regular state elected judge. The same lawyers see the same judge over and over again multiple times during the course of a year. So that by itself would not get that judge removed either. So conversely, if you're doing that with a private judge, you've got the same scenario, and so it makes sense that there would not be an automatic removal. But speaking of that type of case, and I'm sure that was in California.
Yes.
Which is where all this began, with the Silicon Valley, with all the money out there, and all the people in California. Instead of waiting 3 to 5 years to get in front of a judge and have your case heard, private judging was a great alternative for the folks in California. Now, not every state that has a private judging act is exactly like California. Our act is not exactly like California's act, but it is similar. And I'll fess up, it was the genesis of coming up with the act here in Alabama, although we did check other states and we pulled some information from other states doing the same or similar things. Now, as far as the numbers of cases that are being tried or going to private judge, I think lawyers and judges throughout the state of Alabama are still a little hesitant on pulling that trigger. I can't speak specifically for the lawyers. All I can speak to is what some of the judges have told me. And the judges, again, I don't think the judges are getting their feelings hurt by a case going privately. It's just one less case for them to have to handle, is what I heard, except for the timeliness of the election to go that route. I don't understand how or why lawyers might be hesitant unless it's just a cost factor. If it's a cost factor to their clients, some will say the sooner you make that decision to go privately, the less money it costs you. And I think that's probably true, because if your case is set and reset several times, it costs the client more money to go through that process over a period of 12 to 15 months before they get to trial. If they can get to trial within 4 months or 3 months privately, then it should save the parties money, plus stress of having to sit there and wait and deal with this. And then after you try the case, the anxiety and the stress of, how long is it going to be before I get an order?
Judge, we just had a question come across. The question was, what is the typical cost? That is kind of, it depends on how complicated the case is. Is it going to take 1 day? Is it going to take a week? My rate is $150 an hour. I think Judge Ferguson is a little bit more. I do a flat fee. Judge Ferguson does an hourly rate.
Hourly rate.
So it's just going to depend on which judge you get, and more, but really more how complicated the case is. And with the COVID, we were talking about that earlier. I know in Shelby County, Jefferson County is very lucky in that basically each division of the law has their own courthouse. We've got a domestic relations, a civil, a juvenile courthouse, and a criminal courthouse. Most counties don't. So in Jefferson County, in Shelby County, the judges have already told anybody that has a divorce or any sort of domestic relation case pending that the criminal cases are between September 1st, when the juries came back, and the end of the year. They're not going to be hearing any DR or CS cases. They're just going to strictly be hearing the criminal jury cases. And so, again, if you want your case heard in front of a judge in some counties before the end of the year, I'm sure many counties are probably doing that too, because anybody who's sitting in jail, it really wants their speedy trial, and it's not anybody's fault that the COVID's been out there. So that's something to consider as well. Sure.
And yeah, as you said, each case kind of stands on its own, and you have to, and I presume most of this audience would be lawyers. You have to sit down and evaluate your case and decide, is this something that will be good for my client? Is this in the best interest of my client to go this route? And if it is, then decide to file your paperwork and move forward, and you can get it heard more quickly. If it's not, sometimes lawyers, I hate to use the word, are involved in game playing, where you want to wait. And there may be very specific reasons for the wait, such as maybe one party doesn't really want to go forward. They keep thinking that something's going to change and we're going to get back together. So we delay things.
Well, Judge, we've got one more question.
Okay.
Well, actually, Henry wants to know a ballpark range. Henry, I would say on the low end of $1,500, on a high end of $5,000, just for the judge's services. That's not including the court reporter and or if you need security. The other question from Matthew is, and the reason I'm rushing through this because our hour is almost up, is did I hear you correctly to say that the parties consent the presiding judge shall, as a matter of law, assign the case to the private judge? And yes, Matthew, that's what the statute says. The presiding judge shall assign the case to the private judge.
Right. Well, I'm glad you saw those questions because I don't see them on my screen.
Thank you, Judge Palmer, for sharing those questions from our participants. I did have one question for you. Have you ever had a trial in which one party was pro se, or do the parties have to be represented by counsel?
I've not had a trial as a private judge where the parties, one or both of them were pro se. I've always felt like the private judging trials are lawyer driven, and because most parties wouldn't really know about private judging without the lawyers.
Well, I had one where both parties were represented. It was a week trial. Both parties were represented by counsel when the case started, but halfway through, one of the parties fired their attorney and wanted to proceed pro se. So I said, okay, just as if I were an elected judge on the bench, because we were 2 days in of a week trial, and she decided to fire her attorney. So.
Well, thank you for answering that question. We are just about out of time. So panelists, I'll just give you a moment for some closing remarks. And to our audience, we do have their contact information here on our slide if you'd like to reach out to them. So any closing remarks?
Well, as one of the originators of the act, I still believe it is a viable act. I think it's a viable alternative to having your case heard. And the sooner you make that election, the sooner you can get your case tried, the sooner you can get an order. And in my experience, you generally end up saving money by going that route earlier rather than later.
Well, thank you very much for your remarks. And ladies and gentlemen, I do want to make you aware that the private judge roster is maintained by the Alabama Center for Dispute Resolution. You can search for private judge at www.alabamaadr.org. You can search by name, by county, and by practice area. So if you're interested in that, using that form of alternative dispute resolution, and given our current situation, that might be an option for you and for your clients to consider. And maybe, as Judge Ferguson and Judge Palmer pointed out, consider whether that's a better alternative for your clients to get some justice sooner. Thank you, panelists, for joining us today. You have definitely educated us on the who, what, when, where, and how of private judging. All the materials will be emailed out to our participants. Those include the PowerPoint presentation, an article written by Judge Ferguson, and a newsletter from Judge Palmer. And so look for that in your inbox later on this afternoon. The act is codified in the Alabama Code at section 12-11A, sections 1 through 8. So if you're interested in looking that up. I want to thank everyone for taking time out of your day to join us. We're very grateful that you did, and for this Mediation Week event. I also want to give thanks to the Dispute Resolution Section of the Alabama State Bar for co-sponsoring this event with the Alabama Center for Dispute Resolution, and also to the Alabama State Bar for helping to publicize this. You know, we are in the middle of Pro Bono Month at the Alabama State Bar, and this is a great time to celebrate with them. And so with that, I would again thank Judge Ferguson and Judge Palmer for joining us today, and this will end our program for everyone. Thank you all very much, and have a good day.
Thank you, Eileen. Thank you, Judge Palmer.
Yes, thank you, Judge Ferguson. Thank you, Eileen.